Good evening, distinguished colleagues and learned senior advocates of Nigeria. I would like to acknowledge the President of the Nigerian Bar Association, Mazi Afam Osigwe, Senior Advocate of Nigeria, the Chairman of the NBA, ICLA, Professor Festus Emiri SAN, and my fellow board members. My name is Sarah Omega Ajijola. I am the Director of the Nigerian Bar Association, Institute of Continuing Legal Education. I will be your moderator for today's training section. I welcome our esteemed legal minds. It's a pleasure to see you, so many dedicated legal professionals gathered here today for this crucial training section. As you all know, continuing education, but a necessity in our ever-evolving legal landscape. The Nigerian Bar Association, its Institute of Continuing Legal Education, is committed to professional development by equipping us with the most relevant knowledge and skills to excel in our practice. At this training section alone, we have 7,495 registered lawyers. This is unprecedented in the history of the NBA virtual training and indicates that lawyers are eager to comply with continuing professional development requirement and take their professional growth seriously. To ensure a smooth and productive section for everyone, we have established some few ground rules. Please mute your microphone during this training section. Use the Q&A box to submit your questions. During the Q&A section, you can raise your virtual hands. When acknowledged, you may speak and ask your question. Today, Sunday, July 9th, 6th, 2025 marks another significant step in our professional development journey. The topic themed Fundamentals of Strategic Influence in Legal Practice is timely and directly
they will be able to listen.
To serve our clients and uphold justice effectively. Today, our speaker will teach on critical role of strategic influence in legal advocacy, offering actionable frameworks to ensure and enhance decision-making in the justice sector. Now, without further ado, it is my distinct honor and privilege to introduce our guest speaker for today's NBI daily training, Dr. Austin Tam George, a leading public intellectual and a communication strategist whose distinguished career spans academia, government, oil and gas, and international advisory roles. Dr. Tam George holds a PhD from the University of Witwatersrand, South Africa, and was a senior executive fellow at the Harvard Kennedy School in Cambridge, Massachusetts, where he studied communication, leadership, and public policy. For 30 years, Tam George has worked with experts and professionals from over 70 countries. He was Andrew W. Mellon Postdoctoral Research Fellow at the University of Cape Town, South Africa, and was in the International Faculty Program cohort at the IESE Business School, University of Nueva Barcelona, Spain. And George's insights have not only shaped public discourse in Nigeria, but have also resonated globally. He's a member of the Harvard Business Review ABR Advisory Council, where he helps to shape global dialogue at the intersection of communication law, strategy, and public policy. Dr. Tam George blends scholarly rigor with decades of hard-won insight across different sectors. In 2022, he served as a technical advisor to UNESCO Paris, advocating the expansion of broadband access to schools in Africa and around the world. We are truly excited to have Dr. George share his expertise with us today. I'm certain that this section will be enlightening, interactive, and highly beneficial. Thank you as we look forward to a very productive training section. Please join me in welcoming Dr. Austin Tam George. I yield the floor to you, sir. Thank you very much.
Thank you, Sarah, and thank you for inviting me to the platform. Good evening, everyone. Thank you for coming to the platform. Sarah, I have to confess that I'm using Zoho, this particular app, for the first time, and I seem to be having an erratic system here. I hope I'll be able to do this without technical problems. Okay, so let me just go straight to it. Joseph, can you put the slide on the screen quickly so that we can proceed? You know, the question of influence is something that is a subject that is very important, and it is multidisciplinary in nature. If it is in law, of course, lawyers typically spend their entire careers talking about how to protect the interests of their clients and to make sure that they lead advocacy in a way that will deliver the kind of outcome that they want. So they tend to spend a lot of time, getting involved in arguments in court or in mediation settings to make sure that they protect the interests of their clients and actually get favorable judgment if the matter is a matter before a judge in litigation and so on. If it is in sports, there's also a tendency for those who own clubs to outcompete each other by making offerings, by making sure that they propose pay in a way that can make premium players to choose their club side. In fact, in the past 1 week or so, we've been seeing all kinds of clubs making offers to the Nigerian striker Victor Osimhen, offering staggering sums of money to make sure that they comes over to their club side. So using money, using financial propositions to make players to choose a particular club side is also a form of creating influence as far as decision making is concerned. We also see a great deal of persuasion and influence when marketers are persuading you, people in sales are persuading you to try to make a particular purchase one way or the other. So the industry that is now known, as the influencer industry, in fact, in the age of social media, is now over, $15 billion strong. So influencing is a very critical component of advancing a particular interest. So what we are going to do now in this particular session is to be sure that we understand how to create and deploy influence within a specific context of legal practice, because legal practice is very different from sales, different from economics, different from marketing, and different from any other field. And there are three fundamental reasons why influence creation and deployment are different in law compared to other disciplines that we've just mentioned. Can we just move to the next slide, please, Joseph? So I've mentioned, just to repeat, I've mentioned that once you are talking about influence, you are basically talking about how to change people's behavior, how to change people's opinion in the direction that you want. And as I said in the introduction, it is a multidisciplinary subject. Next slide, please. We've seen that even those who are seeking work, that is, those who are seeking to enter employment, typically want to be hired. They tell recruiters, why don't you hire me, rather than the other person. So simply wanting to be hired instead of another person means that you've got to create a condition in which you influence people and try to change their opinion or behavior towards you. Can we move to the next slide, please? So this is a very important subject, and we'll see how it is different from law versus other disciplines. Now, as we move on, you will see that there are three main reasons why influence creation and deployment are different in legal practice. It is different in legal practice for three reasons. One is that in legal practice, are able to give judgment not on the strength of the power of your advocacy, but on the strength of other considerations Society may have to make a choice then between the reign of anarchy and the rule of law, because typically lawyers are trained to make sure that they are able to advance adjudication in a way that will improve the quality of justice and the pursuit of justice, and that people can say, look, because of the rule of law, I'm able to approach the courts in order to get judgment. But if the quality of advocacy doesn't matter, it means society may be moving towards the precipice and then eventually descend into anarchy. So the quality of advocacy in law is very different fundamentally from every other sphere of discipline, because, as I said, it can make a difference between liberty and incarceration. It can make a difference between whether a person will go home alive or the person will end up in death row, or whether society itself can gravitate between anarchy and the rule of law. Now, not every advocacy is qualitative advocacy. How can we make sure that a lawyer who is going to court or who is going to other centers of legal interaction is able to get the kind of quality advocacy that the person deserves, sufficient and impactful enough for the person to be able to change minds, to be able to influence judges' behavior towards a particular case? There are two ways in which you can do this. Can we move to the next slide, please? I've already passed this point. Can we move to the next slide, please? There are ways in which you can make sure that the quality of your advocacy succeeds. The first is clarity. Whether you are writing or whether you are leading an oral advocacy, these days more and more lawyers, in fact, studies show that 86% of the time, lawyers are writing. As soon as lawyers accept a brief, they begin to write down exactly what they are being told, so that they can engage the client before they lead advocacy. So the point is, when you eventually accept a brief, whether it's in writing or in oral advocacy, the most important questions you need to ask is whether your advocacy, the quality of your advocacy, is clear enough. Is it easily understandable? Can people understand what you've written, your written address before a judge? Can the judge, without so much problems, understand what you're talking about? Is it understandable? There are grammatical errors, you may want to expunge them. These days, with the advent of artificial intelligence, there are applications that can double check the grammatical correctness of your advocacy. If it is written, you want to make sure that there are no grammatical errors. Are there spelling errors? All these can be impediments to clarity. Are there spelling errors? Now, in this case of spelling errors, they may not be spelling errors as words. There may be errors in terms of jurisdiction. For instance, if you are working within the American jurisdiction, you need to speak to American spellings. But of course, if you are working within the Nigerian judicial system, you need to stick with British spellings. So the spellings may not themselves be wrong, but they may be jurisdictionally inaccurate. So you need to know within which jurisdiction as a lawyer you are functioning, so you make sure that the spellings that you've chosen are appropriate to the legal jurisdiction in which you're working, or where your audience actually are located. So it may not be spelling errors in terms of the words themselves as much as the jurisdictional applications of the spellings you choose. So if it is an American jurisdiction, please stick with the American jurisdiction. If you're working within the British Commonwealth, including Nigeria, stick with the British spellings. Now, you also need to eliminate ambiguity. So if you follow what I'm saying so far, you'll see that clarity is not just a purpose, it's actually a destination. And these errors that are on the screen can be impediments to you arriving at a destination of clarity in your advocacy. So ambiguity is one of the obstacles. Some of the ambiguities may actually be grammatical, or sometimes they may be in the choice of language mode itself. Let me explain what ambiguity means, even though I suspect that most of us know what it means. Ambiguity happens when an expression is capable of producing two or more meanings. When an expression is capable of producing two or more meanings, then you say an ambiguity has happened. Typically, ambiguities happen when we use figurative expressions. So if you are a lawyer, maybe the hint here, the take home here would be that you probably should avoid as many figurative expressions as possible. For instance, rather than saying that Tina has kicked the bucket, which you can normally say in everyday expressions, within the specific context of legal advocacy, it's probably better to say that Tina is dead. Now, when you say Tina has kicked the bucket, people may understand it in two ways. It may mean that literally Tina saw a bucket, kept in front of her door, kicked it, and then warned her neighbor to say to keep her items more carefully. Why are you keeping buckets in front of my house? She kicks it literally in anger and then moves into her apartment. Literally. But of course, at the figurative level of expression, it could mean that Tina is dead. So if you are using figurative expressions in common balances, in common settings, it's probably not a bad thing. But within the specific context of legal advocacy, it is advised from a communication standpoint that you limit yourself to literal expressions, that is, expressions that mean exactly what they say. So rather than say Tina has kicked the bucket, maybe what you should say within the context of legal advocacy is to say Tina is dead, in which case there is no chance for ambiguity, and there is therefore a complete elimination of misunderstanding. Sometimes it may not be as straightforward as that. Sometimes it could be that the legal practitioner is using proverbs. Proverbs are philosophical expressions. So in order for you to understand them, you need to enter the cultural context in which those proverbs are used, the cultural context from which the proverbs themselves originate. Therefore, because there are an infinite amount of cultures, it is possible for proverbs to be misunderstood because the people who constitute your audience may not be people from your culture. Therefore, they may not understand the proverbial meaning of the expressions that you're using. Now, proverbs are not inherently bad in themselves. You can use them, they are philosophical, they convey special kinds of cultural meanings. But within the specific context of legal expressions, within the context of legal advocacy, it is very important and well advised to avoid the use of proverbs, because your audience, those who are potentially going to be receiving or interpreting your legal advocacy, may be people from a completely different cultural context. Therefore, they may not understand you. So the advice here is for you to eliminate ambiguities, use surface meanings, use literal expressions, so that everybody, both counsel, judge, and client, and those who potentially will be looking at the advocacy or listening to you, will understand exactly what you do. That's about advocacy, ambiguity. You can also avoid the use of fanciful expressions. A lot of people have the tendency to feel that they want to impress rather than express. My own personal communication injunction. Good. So some of the things that I have said, I will just basically try to recapture them. And I was suggesting that it is important for lawyers at all times as they lead advocacy to be clear. It was at a level of clarity that this thing actually tripped up. When I was saying that there are so many impediments to the destination of clarity, I said there should be grammatical errors eliminated, there should be jurisdictionally accurate spellings, and there should be ambiguities that should be eliminated. So I was saying that. And then avoid as many jargon. Jargon are not bad. I mean, if you use registers, what they call registers, every profession has them. Eliminate fanciful expressions and try to be as clear as possible by using simple and clear expressions. Eliminate undue repetitions. That is, repetitions are not in themselves bad because you can use them for emphasis. But when they become undue, is when you use them to the point where it becomes boring and then people are unable to get the fundamental points you're making. The next point, of course, is the coherence of your advocacy. Is this systematically, if it is in writing, and when I speak about writing, I'm also talking about other forms of advocacy, even if you're leading an oral advocacy. But is this systematically presented in a way that the judge or the adjudicator or any person who is in charge of the mediation process, depending on the context, can actually understand what you're doing? Is this systematically presented? If it is in writing, make sure you use paragraphs to delimit the flow of your ideas so that there will be systematicity in the way you present your ideas. It is possible most times to express your idea. One idea, can be expressed in one sentence or in a group of sentences if it is in writing. Always make sure your main ideas, shine through. Especially here in Nigeria, where judges are burdened with a lot of workload, they have very little patience to even look at any kind of material that is not coherently articulated. So coherence is extremely important in legal advocacy. One way to tie one end of your writing to another end of your writing is to use conjunctions. In grammatical terms, they use conjunctions, words like however, more so, furthermore, and those are expressions. Those are grammatically called conjunctions for a reason, because they link one segment of your ideas to the other. In fact, in legal communication, what is known as the IRAC rule, is meant to impose structure and coherence on legal advocacy. Of course, I in IRAC means issues. Then R in IRAC means the rules of law, the principles of law that are implicated in any particular case. Then the A in IRAC means analysis. So that is the zone where you really do your analytical work, showing cause and effect, showing the role of case law in connection with present case, making sure that you bring in precedents to speak to the current case. That is the level, the A, that's where you do the bigger part of your advocacy, which is the analysis. And of course, C means the conclusion. So this kind of systematicity, this kind of structural presentation of your ideas is what is called coherence. In fact, if your ideas are not coherent, the opposite will be incoherent. The opposite will be chaotic. The opposite will be rambling advocacy. And no self-respecting lawyer wants to present an incoherent advocacy. And that is why, rather than think about, people talk a lot about verbatim, but at the level of coherence, the word that you should follow is actually seriatim. That is like stepping on a staircase, one step at a time, point following point. That is what coherence means. So coherence is a very important aspect of legal advocacy in terms of structure. We've talked about clarity, making sure that your advocacy is clear, people understand. Even those who disagree can know what they are disagreeing with. Of course, it has to also be structurally coherent, and that is where coherence comes in terms of systematic presentation. But the more fundamental zone of influence is not just clarity and coherence. According to Aristotle, every advocacy, whether it is in speech or whether it is in writing, must have 4 main appeals. They are right here on the screen. 4 main appeals. The first is logical appeal, always sometimes known as logos. I will explain all of these things in detail. The second is emotional appeal, also known as pathos. The third is ethical appeal, known as ethos. And the fourth is called agora, which is accepting a culture of open debate. I'm going to go into these things one by one so that we understand exactly how they help to create a climate of influence, how we are able to use each of these, frameworks to create an influence, whether it is in the context of mediation, in the context of negotiation, or in the context of litigation in courts. Now, logical appeal requires us to answer the question: this advocacy, this point we are trying to make across, is it meaningful? Does it make sense? Is it logically appealing? Because you can't convince somebody if the advocacy is not sensible. So at the domain of advocacy, when you want to advance logical appeal, the most important things to consider is whether your advocacy makes sense. Does it make sense to the judge? Because only when it makes sense can it have an impact. Now, when it makes sense, does it make superior sense? Because in most cases, the judge already has an opinion about a case that is now before him or her. How can you make sure that the quality of your advocacy advances superior logic so that the judge will say, well, I knew this, but I didn't know it exactly to this degree. So how can you make sure that you are demonstrating superior logic? Anybody who is writing a written address or composing a written address or wants to change minds, to change the opinions of a judge, your writing must demonstrate superior, compelling reasoning. And the way to do this is to conduct research. Research enables you to know case law that is relevant to a particular case. It enables you to analyze evidence in a way that's relevant and resonant to a particular case. It enables you to know whether there are witnesses that can have an account or have accounts that corroborate the main brief of your client. In fact, having witnesses as a pre-trial activity, having to interact with witnesses, you've already accepted the main brief. But now you need to know whether there are people who can support the main brief itself. So if there are witnesses, what you do is to have a pre-trial activity, pre-trial session with the witnesses to make sure that their accounts actually support the brief that you received and now need to lead in court, or as the case may be, in mediation. So research means getting more information about a particular case. You can conduct research by interacting with witnesses. You can conduct research by visiting the location of the incident in order to better understand the evidence. In some cases, in fact, there was a time when in Lagos, they set up this NSAS investigation commission, hearing all different kinds of accounts regarding this NSAS incident. And at some point during the sittings, the members of the commission had to go to the Lekki toll gate, which was one of the major locations of the incident. Why did they go there? Because that was that was the place of the incident itself, where they said there was a massacre, and the members of the commission had to, visit this particular location in order to better understand the evidence that they tendered before them. I remember in 2008 when I was teaching at the University of Cape Town. One of those days I came to Nigeria on vacation, and there were problems in my community, where some political thugs had invaded the community and, raped some women, burned down 13 houses, and took some people and killed them and all that. So when the government when a new government arrived on the scene and set up a commission of inquiry, my community submitted a petition against some political actors that instigated the crisis. It was Justice Kayode Esho who was the head of the commission. They had to visit some of the locations where some of these incidents took place. So visiting the location of an incident is a way of conducting research, a way of assessing the validity of evidence, and generally understanding the context of a particular incident. All right. So the logical appeal of your material, of your advocacy, can actually increase as you gather as much supporting information as possible. Remember that within the specific context of labor practice, facts are important, not speculation. Evidence are important, not make-believe or hearsay. So when you conduct research and you put all these materials together, analyze them in a way that make them resonant, it means that you are able to make a compelling logical presentation before the judge, and then that will raise the logical appeal of your advocacy, and the judge will say, look, I didn't know this now, but now that I have evidence before me, I have a compelling argument before me, I think this makes sense. So logical appeal is extremely important in raising the possibility of influencing judgments. The second point, of course, is emotional appeal. According to Aristotle, we are not just logical people, we are also emotional people. Sometimes people you can't reach logically, you can reach them emotionally because you're able to strike at their hearts. Now, that may be true in all other cases, but in the specific context of labor practice, emotional appeal must closely align with logical appeal. Now, I need to make this clear. Being, staging an emotional appeal in your advocacy doesn't mean, to launch melodramatic scenes in court. It doesn't mean that, well, you need to cry in court or otherwise, shout and demonstrate and do all kinds of things physically in court. No, that is in fact likely to be an unethical practice, because you are supposed to, comport yourself in a professional manner. But there are other ways you can present your evidence in courts in a way that can raise the emotional quotient of your advocacy. Because what you're looking for is not just to make a logical appeal, but you want to strike at the heart of the judge. Emotional appeal enables the person who is listening to you to have a deeper connection with your message. One way you can raise the emotional appeal of your advocacy in law is to back up your evidence, but using specific ways of deploying your language. I don't know how big the screen is, but let me give you an example. We are going to have 4 sentences because there are, I understand, thousands of people on the platform. We won't be able to speak to individuals in order to explain this. So I've put this thing in the form of examples. There are 4 sentences here on the screen. If you follow these 4 sentences closely, you'll see that each sentence has a different emotional impact, and that each step increases the emotional impact of the sentence. In the first sentence, we have a woman was killed. Now we know generally, broadly, that women are seen as vulnerable members of society. So killing a woman already has a certain emotional quotient to it. Killing someone is bad enough, but killing a woman has a particular uniqueness to it, because women, just like children, are seen as vulnerable members of society. In fact, when I was in South Africa, I don't know how it's done here in Nigeria yet, but when I was in South Africa, the whole month of October, the whole month of November is dedicated, to advocacy against gender-based violence, especially protecting women. For children, of course, we also know that the Child Rights Act specifically makes provision for the exceptional protection of children. Why? Because women and children are seen as especially vulnerable members of society. So when you kill a woman, there's already an emotional implication to the crime, other than simply being a crime. Now, in the second sentence, we say an innocent woman was killed. Now, remember that in the first sentence, a woman was killed, but we are not so sure whether the woman was innocent or not. But by providing more information in the second sentence, we raise the emotional impact of the case. The woman was killed was bad enough, but now we are providing more information by saying that The woman that was killed was in fact innocent. Now, when you kill an innocent woman, that's worse than simply killing a woman who probably may be guilty. But in this case, we have additional information that the woman that was killed was innocent. In the third sentence, we say an innocent pregnant woman was killed. I don't know about you, but this raises the impact of the crime. This woman, this person that was killed was not just a woman, she was an innocent woman. But now we have additional information that this woman that was killed was in fact pregnant. Now, if you were a judge, you will see that this kind of gradation in the presentation of information also, raises the stakes in terms of the degree of crime that has been committed. A woman was killed. We now know she was innocent, but we also now know in the third sentence that this innocent woman that was killed was in fact pregnant. Now, of course, the implication is that this woman was not only simply killed, the fact that she was pregnant may mean that another child, another person's life has been taken away, namely a child. This woman was pregnant. Now, in the fourth sentence, we say an innocent pregnant woman was killed in the presence of her young children. Now, all these are information about a particular crime, but you can see that because of the additional information that has been presented and the manner in which this information has been presented, not only are we presenting information, we are raising the emotional stakes of the case. When you kill an innocent pregnant woman in the presence of her young children, the implication is that we are not only dealing with the killing of someone, we are not only dealing with the killing of a pregnant woman. It appears as though the impact of the crime may continue to haunt her children, in whose presence she was killed. So you can see that by presenting your material in this way, you are not only presenting facts and evidence, you are actually raising the emotional quotient of your advocacy by presenting the information and evidence in a systematically impactful manner. That's what I mean by raising the emotional stakes of the matter. Now you can see that I need to enter a caveat here that these are not just information. Because you're legal practitioners, this information must be materially correct. For instance, the fact that this woman was pregnant shouldn't be a matter of the opinion of a counsel. If a woman was innocent, her innocence must be legally established before the court. If a woman was pregnant, it's not enough for the lawyer to say so. It will require the presence of an expert witness, such as a forensic pathologist, who would examine the corpse of this woman, of this dead woman, and establish that she was actually pregnant. It's not up to you to say, well, look, because I want to appeal to the emotion of the judge, I need to say that this woman that has been killed was pregnant. It's not enough for you to say so. You must present evidence, because you're lawyers, you're not salespeople, you're not propagandists and all that. You are lawyers, and your stock in trade is to make sure you assemble the facts, is to make sure you assemble the evidence. In this particular matter, it's not a matter of speculation. It's not you simply suggesting that the woman may have been pregnant. No. You have material evidence in the form of a report presented by an expert witness, in this case, a forensic pathologist, who says, we conduct a forensic work on this woman, and we were able to establish that this woman was indeed pregnant. So you present these facts as evidence. If this pregnant woman was killed in the presence of her young children, those young children must be presented in courts and their accounts taken, testifying that they were actually present when their mother was killed. Now, what am I saying? What I'm saying in a sense is that The emotional appeal of a case is not necessarily for you to go and cry in court or dramatize in court or launch it into some kind of melodrama in court. No, the way you can raise the emotional quotient of your advocacy is by making sure you marshal not just the evidence, but the way in which you present them. And from a communication standpoint, I've just demonstrated how you can see step by step how the emotional impact of a case can be presented simply by making sure you present the facts in a coherent and systematic fashion. So you can see how the emotional appeal can rise in a case. But you see, I need to enter a caveat here. Do not use emotional appeal for manipulative purposes, because that would be professional malpractice. There's a tendency for people to mobilize emotion in court or in other kinds of legal interaction in order to want to manipulate the audience or somehow try to emotionally blackmail the judge. No, do so using evidence and the manner in which you present evidence, just the way I've tried to demonstrate on the screen. Now, the other third appeal, remember before we had the technical issues, that we are talking about four main appeals. It's not enough that your advocacy is clear, important as that is. It's not enough that your advocacy is systematically presented, as important as coherence may be. But you need to make sure that your advocacy, whether it is in writing or whether it is an oral advocacy, that it has the potential to influence judgment. The third such appeal is the ethical appeal, also known as ethos. Now, ethos refers to the credibility or the character of the person who is wanting to persuade others. In law, you already have the ethics of the profession. That's part of the ethos. The elements of ethical appeal include domain expertise. How do you raise your ethical appeal in the profession? Your credibility is very, very important. And the pillars of credibility that you need to build in the profession are two of the two main pillars. One is you've got to know the subject itself. It's not enough to say I've been called to the bar. It's not enough. Look, every single case challenges a lawyer afresh, whether you've been in practice for 50 years or whether you're just entering the profession as a newbie. You must have domain expertise. If you know the subject, your credibility is going to rise in the profession. So domain expertise enhances your credibility. Like, when Sarah was introducing me, she mentioned some of the things that I've done. In the past 15 years, me and my colleagues, senior friends, Professor Yemi Oshibajo, who later became our vice president, Georgie Tomi, who has practiced law for over, I think, 46 years, is a life venture, and some of my colleagues in the institute, Abimbola Akeredolu, who is an SAN. All of these people, we've been training lawyers since 2010, thousands of lawyers. I've been doing this work overall for 30 years. So you have domain expertise in what you're doing, and you need to demonstrate it across the board. And every case challenges you afresh. You must know the law if you're a lawyer. That's what domain expertise is. And you need to be able to bring that knowledge and apply it on a case-by-case basis. The second pillar of building your credibility in the profession is to have a demonstrable ability to make good judgments. Should this case go to trial, or should we advise our client to seek alternative means of resolving this conflict? Of course, ultimately, it's up to your client. It's up to your client to be able to make the decision. But you should be able to make a good judgment to say, look, if we follow, these are the options available for you if you're seeking legal redress. You can go to trial, but these are the options open. These are the chances of success in my estimation. Or we can pursue settlement in one way or the other without going into the lengthy and often expensive path of litigation. You need to be able to demonstrate that ability to make good judgment in a way that will ultimately enhance, the pursuit of justice. These are the two pillars of building your ethical appeal in the profession. I know that in some jurisdictions where there are all kinds of people, where there are all kinds of situations where people don't care about credibility, but you must worry about your credibility, as a professional. Now, other elements of ethical appeal is just your character. Do you have a sense of proportion? Sense of proportion here means resisting the temptation for exaggeration. Sometimes when lawyers present their cases in court, or they are presenting or speaking to evidence or trying to present facts, they sometimes succumb to the temptation of exaggeration or sometimes even fabrication. Not only is that wrong, it's a professional malpractice. So part of your character as a professional is to, have that sense of profession, that sense of proportion, to make sure you operate within the zone allowed by facts, allowed by evidence, supported by evidence. Even the way you dress is always interpreted as part of who you are. That is why in the legal profession, of course, there's a dress code. There's a reason for that. The reason is that the totality of your personality is reflected in your professional status. So even the presentability, the way you look, the way you dress, can make people understand. Are you approachable? Yes, you are pursuing the interest of your client. But are you approachable by other counsel in order to explore other ways of resolving the crisis? Do you demonstrate empathy? Empathy means putting yourself in the shoes of another person and understanding that sometimes life happens. So are there ways you can demonstrate empathy even as you pursue justice? Another way of demonstrating good character is being respectful to the other side. Are you respectful? There was a case, of an account someone was given during one of our trainings, where the person was suggesting that, look, there was this case and I was making my presentation, and the other counsel was an SCN, and then they spent a whole lot of time, trying to, castigate me, show disrespect and all that. That is not ethical behavior. You can always make a case, stand your ground, support your clients, be adamant about the correctness of your own advocacy, while showing respect to the other side. All these things are part of what raises, your ethical appeal, both in court, in negotiation, in mediation settings. Part of showing respect is also your ability to listen. Even if you want to disagree with the other counsel, you must show respect by listening to the other counsel. Here, if it is your client, you need to hear out your client, ask questions, be involved in an inclusive communication process. Even if you disagree, you need to have that patience to listen to the other side so you know exactly what you're disagreeing with. In most cases, we see that lawyers tend to be disrespectful to the other. They don't even want to hear the other side. I think that you can have a civil debate while listening to the other side. Listening, not just hearing, but listening attentively, so you know exactly why you disagree. In fact, if you know exactly why you are disagreeing, you are likely to disagree even more strongly. But you have to listen. So that is part of, being respectful. The totality of these elements build your character, and constitute what we call the ethos. So that when the judge sees that you're demonstrating good character, or follow court procedures, Do not neglect the judge or disrespect the procedures of court simply because you want to lead advocacy. You may end up annoying the judge. You may end up pissing off other people in the justice sector. Make sure you follow the rules of the court, show respect, and lead your own advocacy as much as you can. The other point, the final point here, is called the agora. Of course, historically, agora refers to the ancient Greek context, a marketplace where debates happen, where people just go physically, to debate, exchange ideas, get some of the finest ideas, to win the day. So this culture of debate is was considered very critical. In fact, in ancient Greece, they had specific locations where people gathered for debates. These days, there are, modern versions of it. There is this, there are places at the University of, Oxford, where, you go to particular halls where debates happen. In 2025, when I went to the School of Oriental and African Studies, SOAS, University of London, I saw firsthand this culture of debate. People simply sitting, debating on one side, and then changing rules and debating on the other side. Within the context of legal advocacy, agora would mean that you internalize this culture of debate, this culture of open debate. You hear one side and you hear the other side. You switch roles. In some chambers, I don't know how many chambers do this as a matter of tradition. But in some chambers, before even a case is heard, lawyers argue on both sides of a particular case. That would fall within the context of modern version of agora, where people take rules and argue on both sides of a particular case, changing rules in order to make sure that you show that intellectual dynamism to be able to argue a case on both sides. It helps the quality of advocacy because it shows mastery on two sides of a particular case. I think that much of it should be, consolidated and, deepened and institutionalized in our legal training process. I know that we have the mock trial system from the university setting up to the law school setting before, lawyers enter the profession. But I think we need to revisit the mock trial tradition and try to make sure that the highest quality standards are set. Highest standards of quality are set at the mock trial sessions at the university level. I don't know how rigorous they are these days, but they should be as rigorous as part of the legal training of students from the university setting up to the law school. So by the time they get into the profession, they already have internalized this culture of open debate, so that when they go to court or any kind of legal interaction, they understand that people can disagree with you without being disagreeable. It's part of the tradition of advocacy. So within the context of, creating and deploying influence, agora would mean embracing this culture of open debate, and it can take the form that I just spoke about, where lawyers are able to, take different sides of a particular case and argue as persuasively as they can, so that by the time they actually get into the real thing in courts, they can anticipate the argument of the other side and then be intellectually and legally ready to challenge the other perspective. Now, another component of agora is the ability to interpret the audience. In Nigeria, we don't have the jury system, as they have in the US. But right here in Nigeria, we are the judge, or sometimes, where you have a body of justices, a number of justices, hearing a particular case. They constitute the audience. You need to understand this audience, if they are a body, if they are a lineup of justices. Interpret this audience very correctly, and then launch your advocacy. Because you won't be talking to yourself, you'll be talking to judges who will be adjudicating a particular matter and are the deciders of a particular case. Understand them. That's why I said understand the rules of court, follow the rules of court, show character, make sure you conducted your research, as I said, at the level of logical appeal, at the level of emotional deployment, at the level of your ethics. Understand that these judges are not just going to be listening to you, they're also seeing how you comport and deport yourself. So understanding the audience is very important, as you try to launch your advocacy. The third point with Agora is ability to respect the opposite view. As I said, in every advocacy, there are more than one area, one perspective. You need to be able to understand that just as you've taken a position on a particular subject, others also have their own perspectives. You need to show that dynamism to say, look, I understand this other perspective, but this is where I stand. So ability to respect the opposite view, even when you disagree, is part of what constitutes the culture of debate. Okay, so when you disagree, you know what you're disagreeing with, even as you show respect. I remember that there was one time in the course of our trainings where somebody was saying that after during the actual session in court, while he was making his case, and the other counsel was also making her own case, there were moments when, they were talking to each other, and even when there were amusements, they laughed, and then at the end of the session, they shook hands, patted each other on the back, and went their separate ways. But eventually, the client was not happy with it. He said, "Why were you laughing with the other people? These people are trying to put me in jail, and here you are laughing and chatting and discussing. Why were you, appearing friendly to the other side?" So he was saying, no, that doesn't affect the determination of the matter. It doesn't affect the quality of my advocacy. I'm not in any personal war with the other counsel. I'm on your side. I want your interest protected, but that doesn't mean I've established an adversarial or an enmity, with the other side. No, I am on your side. The advocacy is going on. But I just show respect and show, friendliness towards the other side. It has nothing to do with the quality of legal representation that I'm giving to you. Okay, so the final point about Agora here, as a protocol of creating influence, is showing the capacity of civil dialogue. Some people disagree to the point they become disagreeable. It doesn't have to be. You can actually disagree in court or in any kind of legal setting, and yet be able to conduct the disagreement in a civil manner. Some people go to court and insult their colleagues, or sometimes they write letters to their colleagues in very insulting language. All those things are not necessary because it doesn't actually improve the quality of the advocacy. It doesn't widen the chances of success of a particular advocacy. So you can disagree and yet be agreeable. That is, I disagree with you. I have no personal enmity with you. Let the case be decided on its merits. We have the facts here. We have the evidence. We have case law that supports our advocacy. But I have no personal enmity or adversarial relationship with you. So these are some of the things I think you can integrate into your legal advocacy in a way that can improve your chances of influencing, judgments in a way, that will move judgment in your direction. I learned some of these things over 30 years, but 2 years ago when I was a senior executive fellow at Harvard, some of these things, came back to me, and I realized that if you actually implement these things just the way I've suggested them, you can actually, see the quality of your advocacy improve. Now, some people might ask, but if we do all of these things, does it mean judgment will necessarily always be in our favor? Scientifically, yes. If you have the facts, if you have the evidence, and you lead a very powerful advocacy using some of these frameworks that I have suggested, there is a wide possibility that your advocacy will succeed, so long as they are led by evidence. But of course, I can't account for non-judicial factors, such as when there is an intentional perversion of justice. Because if the process of the administration of justice has been corrupted, it means no matter the power of the argument you put forward in court, a judge may have been compromised in a way that makes the judge intentionally want to pervert justice. I can't account for that. In Nigeria, there is a fair consensus at this point that the justice sector is in need of reforms. Part of these reforms would mean to restore the integrity of the justice system and the administration of justice. So if it has to do with cases of intentional perversion of justice, I can't account for that, because no matter the quality of advocacy you lead, if the system is corrupt, there's a chance that non-judicial factors may account for how decisions are made. I can't account for that. But if you're talking in terms of the scientific deployment of the protocols of influence, there is a wide chance that your advocacy will succeed. Look at the matter of legal precedents, for instance. There is a reason why legal precedents exist. At least two reasons. The first is that through legal precedents, we are able to know how cases have been decided in the past and how those cases can influence how current cases may be decided. So you can see that law may be an imperfect science, but it is a science. Why is it an imperfect science? Why is law an imperfect science? Law is an imperfect science because you don't deal with chemicals. You don't deal with reagents like chemistry, where chemicals and reagents are put in the refrigerator, room temperature, and all, where the conditions are sterile. Law is a much more dynamic and messy process because it deals with human interactions and conflicts. So it's an imperfect science in that sense. But it's a science all the same because it has a very fundamental pillar of scientific work, which is predictability. And in law, precedents and decided cases enable us to be able to predict how new cases will be, especially if they have very strikingly similar attributes with this already decided cases. So predictability, which is a central feature of scientific work, is very important, for lawyers. So if you say, look, I'm handling this case now, but I'm not just talking of this case in isolation. There are, in fact, case laws, there are precedents that enable me to think that this case can, in fact, go the way previous cases have gone. There is predictability right there for you. But the second reason why legal precedents are important is that they form the authoritative foundation for current cases. We can cite them. We can say we are not arguing in a vacuum. There is an authoritative basis for this argument I'm launching because there are decided cases. Cases in the past that have similar attributes, and we have decided this way. Therefore, there's a sense in which those decided cases have legal resonance for the current case I'm arguing before you, my Lord. So you can see that law may be an imperfect science, but predictability itself makes law a scientific endeavor. But the moment the administration of justice is corrupted, lawyers are no longer sure how cases will go. In fact, the other day, Olusegun Baesien was on television, in an interview, lamenting that, look, these days you no longer can tell how cases will go because precedents appear to be meaningless, to the justices these days. Now, when precedents are no longer meaningful in adjudication of cases, in the decision of cases, then there is a problem. So, are we in need of justice sector reform? I think there's a fair consensus in this country that this justice sector is in need of reform in terms of restoring the integrity of and predictability of the system. But the other aspect of the reform has to do with improving the quality of advocacy. And that is where we come in to make sure that, look, while the justice sector reform may happen in other ways, in terms of restoring integrity of the administration of justice, the other arm of the reform has to be to deliberately increase the quality of advocacy. And that is what this course is about. How can we make sure we increase the quality of persuasion so that people will be persuaded using the kind of frameworks that I've just suggested? So I think I will end the presentation at this point so that I can take some questions. I'm sorry about the technical hitch that we had, but I seem to have found my way back on the platform. And I suspect that all of you can hear me and see me, and I'll be very happy to take some questions at this point. Thank you so much.
Thank you very much, Dr. Tam George. Thank you for very insightful training on fundamental of strategic influence in legal practice. This knowledge has been very effective and very great for our lawyers in terms of navigating influence and communicating with clarity, engaging in civil dialogue and making decisions, and also hoping that with this training you can even anticipate outcomes and ultimately achieve more favorable results and help our legal practitioner to distinguish themselves and contribute significantly to success of their practice. And I invite our secretary, the secretary of the board, to help us with the question and answer section. Mr. Secretary, sir.
Thank you so much, Sarah, and thank you so much, Dr. Itomi. I enjoyed every bit of your presentation. So there are questions here for you to attend. Now, the first question came from one Sophia Ogene Fejiro. The question reads, how secured, I think this question might be to Sarah. So how secured is this registration procedure? Is there like a means through which the organizers can confirm that everyone who filled the form actually attended the webinar? Maybe it is my overthinking head, but anyone here can just copy the link and share with others who aren't present here. So maybe, Sarah, when it gets to your turn, you can answer this question. Let me go ahead with the rest for
thank you.
the guest speaker. Okani Uzochukwu has a question which says, please, sir, regarding the issue of ambiguity during advocacy, can one say that a document may not fly in court, or is it better and clearer to say a document may not be admitted instead of the phrase fly?
Okay,
you want me to take all the questions?
Let me respond quickly to this because I think it's a very straightforward answer that is required. When you say a document may not fly, that is an informal expression. Law is known to be a very formal, a profession. So I think it is the second suggestion is better. The second form of construction is better. This file or this case may not be admitted. I don't know the example you gave, but may not be admitted in court is better. To say it may not fly is a colloquial expression, and most informal expressions do not quite sit in within the formal context of advocacy.
Thank you, sir. The next question is from Samuel Adeyomo. He reads, in this era of front-loading, how is advocacy affected adversely?
Front-loading, simply means making sure all the aspects of the case are set out in advance so that there are no no nasty surprises during the actual process of litigation if the matter is before the court. So that's what front loading is about, to avoid nasty surprises, and that everybody who is part of the case have the facts that they can deal with. So there is no negative dimension to front loading, because it shows that, look, all the facts are before the court. Everybody, is aware of the facts. Everybody knows the issues, and then you just go there and lead your advocacy, based on the evidence and based on what you consider to be relevant precedent, and then you launch your advocacy. Front loading, as far as I know, in practical legal advocacy, especially in courts, is a good thing, because, as I said, the purpose is to make sure that no new evidence, except of course there are unique situations where you need to present something, there's a new development, and at a particular stage, in the unfolding legal situation in court, you need to bring in new information. But whatever is the case, front loading, seeks to eliminate, surprises in court. So there is no adverse effect that I can imagine when every person who is implicated in all part of a particular case already know the facts and now need to go before the judge, to lead their own advocacy. So front loading is indeed a good thing, because it removes the possibility of a surprise. The second advantage of front loading, of course, is that it gives everyone concerned, an opportunity to respond, to research and respond to each and every component of the case, because they now know in advance, what the issues are, and they will be able to respond, conduct research, gather witnesses. In fact, they engage witnesses based on the facts available to all counsel to make sure that there are no nasty surprises. So two advantages there. Everybody knows what the issues are, what the evidence and the facts are. The second is that it gives you time to prepare, and it's a good thing.
Thank you. The next question is coming from Beatrice Oroma. It reads, to what extent can tech, in bracket, AI, legal analytics, and social media, bracket closes, enhance or threaten strategic influence in modern legal practice?
Can you repeat the first segment of the question? I heard about social media. They said the first one.
It says, to what extent can tech?
Oh, okay. All right. Yes. Incidentally, yes, I get you. Incidentally, we have a whole course at the Institute, and I think the MBICLE has been launching that course with us in partnership. We have a whole full course on AI in legal practice, where we deal with all of these things. But this is a very important question, because it speaks to the intersection of communication, tech, and legal practice itself. These days, artificial intelligence is a completely new frontier in legal practice, because it brings in the component of technology, that enables lawyers to do their job more dynamically. So the NBA, I think last year, recognizing the almost inevitable intrusion of artificial intelligence in legal practice, came up with a guide on how lawyers can use AI, as an enhancer, not a replacement to the lawyer, but an enhancer of legal practice. Now, if you use AI, it will, correctly, it will greatly improve the quality of advocacy. There is no question about it. I use it all the time. But there is a caveat here, and I think the NBA was wise in coming up with the guidelines. Typically, most professionals will wait until there's a national AI governance structure. But the NBA, recognizing that this is a fast evolving frontier in legal practice, came up with the guidelines. Now, a very central component of those guidelines is that in as much as you want to, deploy AI or adopt AI into legal practice, make sure you are not a slave to tech. You must exercise heavy human oversight, because AI deals with machine learning. It has human intuition, but it's not human. In fact, if you use some of these AI platforms like Humata or Perplexity AI or Lex Machina or Grok or ChatGPT, as the case may be, you will get an advanced information sometimes that AI can be wrong. You need to make sure you confirm the information presented by AI. So how can AI be wrong? AI can create what is called artificial intelligence hallucination. They call it AI hallucination. Hallucination in tech means the ability of AI to produce confident but wrong information. When Sarah was introducing me, she said, that I got my PhD from the University of the Witwatersrand in South Africa 18 years ago, in 2007. AI will tell you that I got my PhD from a university in Canada, and it will do so confidently, even if the information is materially wrong. There was a time somebody told me that they checked me out on ChatGPT or one of the, is it DeepSeek, one of these platforms, and they said I was an Indian scholar, and they presented information about me so confidently, even if they are wrong. That is called AI hallucination. Now, the correction of AI hallucination is that you have to exercise human oversight to say, no, this information is not correct. You must follow traditional protocols of verifying information, because AI wasn't called to the bar. You, the lawyer, was called to the bar, and you will be held responsible for any kind of mispresentation in court. So you need to use AI wisely in order to make sure that you exercise oversight on the content generated by AI. AI is very good. It's very solid, and it can enhance your legal practice, but it comes at the price of heavy human oversight, so that you can correct whatever misrepresentations that AI generates. It's called generative AI, by the way. The second thing is social media. Social media, I have been teaching media studies for so many years, and one of the things about social media is that it is not, I repeat, it is not like any other media. Social media was created for things that are not normal. Some people may not understand this, but let me explain what I mean. Normal things don't sell on social media. I'm married, I have a stable family. That's not exciting for social media. But if I were to talk about how I intend to divorce my wife, how I intend to do this, how I intend to how every day, what we eat, how we eat it, what we wear, that is sensational enough. So social media has a particular tendency towards sensationalism, towards extremism, towards what is sometimes called the creation of hyper reality. Hyper reality means this may be real, but it is stretched to the point of exaggeration. So what implication does this kind of media have for legal practice? There is a very strong likelihood that any material that is picked up from social media is likely to be a deviation or a distortion, or sometimes a total fabrication of reality. So be careful how you use social media as a source of information as a lawyer, because of its organic nature towards the creation of hyper realities, the tendency towards sensationalism, and the tendency towards catastrophe. Because that is the nature of social media. There's a reason why it is social. It is social because it has to bring people into a social experience, and the more it does that, the more successful it is. That is why when something explodes on social media, indicating that a lot of people are implicated in the content that has been put out, it's called virality. That is, this material has gone viral. The virality of a content on social media is sometimes an endorsement in terms of how far it has gone in its reach. But is virality necessarily correct? No. Something may be viral and yet manifestly incorrect. But you as lawyers, you deal specifically with facts, not virality. You deal with evidence that is admissible and can be tested in courts, not likes and clicks and virality. So you can use social media, but again, you must exercise a great deal of judgment, in the way you use content from social media, because social media prioritizes virality, while law prioritizes evidence, facts, and reality. So that's my answer to that.
Thank you. Thank you, sir. So there's this question from Vivian Chimwendu. It says, to what extent will an understanding of behavioralism inform a lawyer's strategy during advocacy? There are two questions, perhaps I may have to take them. With the growing use of social media and digital platforms, what are the strategic and ethical considerations for lawyers seeking to exert influence beyond the traditional courtroom settings? Did you get that, sir?
Yes, I think I may have already answered this question in my lengthy
The second one.
Yes.
But the first one is asking, to what extent will an understanding of behaviorism inform a lawyer's strategy during advocacy?
To what extent does what?
Behaviorism. Behaviorism.
Behaviorism. Is that the word?
Yes, please. Yes, please.
Okay, I think this person may have come in after my introduction. In the introduction, maybe I should recap the introduction. I mentioned that the subject of influence goes across different disciplines. I mentioned how influence works among salespeople who simply want you to buy a product, one product over another product. Why don't you buy an iPad, for instance, instead of getting an iPhone? Or why don't you get an iPhone instead of getting an Android? Why don't you get a Samsung instead of Huawei? Salespeople will want to influence you to buy one product over another, and that is a form of the deployment of influence. I also mentioned that in sports, more and more sports club owners tend to use money and other financial offers to influence players. I cited the example of Victor Osimhen, one of our own right here in Nigeria, who now appears to be confused about which of the clubs is going to go to. There's a Saudi club that is making an insane amount of money, offering an insane amount of money to Victor Osimhen, saying that, why don't you come to play for us? While there are others who are also making similar offers. Now, in sports, they can use monetary, offers and conditions of service as a way of influencing decisions. So, if the nature of influence is a multidisciplinary subject, a multi-sectoral subject. But I said that the case of influence in law is fundamentally different in three ways, and I mentioned it 3 ways. It is different because how you influence somebody in law, especially how you influence a judge's decision, can make the difference between freedom and incarceration, whether a person will go home free or whether a person will be imprisoned. That depends on the quality of your advocacy. In another sense, it can make the difference between life and death itself. A person who is charged for murder can either go free or end up on death row, depending on the quality of advocacy of his legal representative, that is the lawyer. And I said, the creation and deployment of influence in law is also different in a third sense, and that is, if everybody believes that some of the things I've said here can actually lead to the rule of law, enhance the administration of justice, that is a good thing. But if you can lead advocacy, no matter how good you are, and judgment is somehow perverted, it can lead to anarchy in society. In fact, there's a problem when those who should be afraid of rule of law are the ones who are advising you, encouraging you to go to court, because they believe that somehow there will be extrajudicial considerations when it comes to actually making determinations in court. So yes, influence covers a broad spectrum of disciplines at different sectors. In the behavioral sciences, I just explained to you how it works. In economics, in law, in physics, all kinds of the way influence works depends on how you deploy it and within what context. In the context of law, influence works in the way that I've just explained it, how you can make sure that a judge, using evidence, using facts, supported by case law, is persuaded through competent, communication skills to decide a case one way or the other. So I think I've answered the question, but I think this individual may have come a bit late to the platform.
Thank you so much. Then the collection of participants are asking for copies of this presentation, particularly because of the hitches we had somewhere along the line and many people joined late. So would that be presented? Then again, they're asking if there'll be a certificate of presentation after this, in addition to the CPD points.
The ICLE will award CPD points to those who have attended this course. And yes, we will release the slides to the director, Sarah, to share to as many of those who have attended this program, so that, in their privacy, they can look at some of these things and see how they can actually use them to improve the quality of their legal advocacy. I have some of these slides. I generated them when I was actually a senior executive fellow at Harvard, where we took a whole course on strategic influence and persuasion. We were taught by a professor who also taught Barack Obama at the Harvard Law School, persuasive communication. So a lot of these things have influences from different experts, professors at Harvard, my own experience over 30 years, and all of these things. So I'll be very willing to share the knowledge and send the slides to Sarah, so she can send to those who want to keep them and use them for their own purposes.
Thank you, sir. So there are several questions, but let me just take a few more because we're almost run out of time. A situation where you have aggressive lawyer on the other side, how do you handle such lawyer? He's always shutting you down with several objections while you are addressing the court.
Okay, so the first thing to understand here, I think, is that our justice system is an adversarial system. We all know that. It's an adversarial system. We all know that if we don't want that kind of adversarial approach, you probably shouldn't litigate. You should choose other platforms for the resolution of conflict. But aggressiveness is different. And I'm happy that you asked that question. Aggressiveness is different. And my suggestion always, and I think I mentioned that extensively during the presentation itself, that, you can disagree, you can lead the advocacy in the opposite direction of the other client, and yet not be aggressive. There are no points to be won in aggressiveness in court. There are no points to be won. Cases will not be decided, on the basis of the volatility of counsel in courts. I imagine that cases will be decided on their merits in terms of the issues, in terms of the facts, in terms of decided cases that can be as I said, the authoritative foundation on the basis of which counsel will argue a particular case. And then on the strength of the communication competence of counsel in court. So aggression, there are there are no points scored or awarded on the basis of aggression. You know, aggression is ultimately a weak point for counsel, because you can be assertive without being aggressive. Assertiveness is a different thing. Assertiveness means you respect the other side and you stand your ground. But aggressiveness means you diminish even your own case, because there is no point awarded for aggressiveness in court. My advice, you know, both to senior and the new entrants to the profession always, is stick to the facts. In most cases, the facts are enough. Stick to the evidence. Present your case persuasively as much as you can. Leave aggressiveness alone, because aggressiveness is it can actually weaken your case. Most judges are not prepared, you know, to see aggression in court. They are prepared to hear the case on their merits. The cases on their merits. So focus on the case. What are the facts? How do you lead evidence? How do you make sure you lead witnesses to support the account you're canvassing before the judge? These are the most important things. No points are scored for aggression in court. Aggression will actually put off a judge and poison the environment. And it may actually, in extreme cases, rise to the level of professional malpractice. Advice against it.
Thank you so much, sir. There are several other questions, but I think you have answered them one way or the other, because they have some similarities with the questions that you have dealt with. Before I let you go, just let me also say that I enjoyed every bit of your training, and I've learned two words in particular. One is hyper reality, as it has to do with social media, and the other is the word you use, AI hallucination. So I'm not giving vote of thanks, but many people have expressed their deep thanks, deep appreciation for the presentation you made. I'm sure the person who is giving the vote of thanks will elaborate on that. So thank you.
Okay. So let me, thanks a lot. Let me quickly, say a few more things about social media, because this is the age in which we live. We can't pretend that social media doesn't impact people. It does. In fact, for those who may have joined us today, I spoke about how there is now, because of social media, there is now what is known as the influencer industry, that is, billions of dollars worth. But we need to be careful, especially as lawyers, extremely careful, because the social media is not like conventional media. The social media was not created for normal things. Social media has a natural, organic tendency for exaggeration, for sensationalism, and the creation of what I call hyperreality. Hyperreality means the reality expanded, magnified beyond proportion. And that runs directly opposite to what happens in the legal profession that deals with the sense of proportion. In law, you can't but have a sense of proportion, because you're limited by the possibilities of facts. You are limited by the possibilities only allowed by evidence. As I suggested during my presentation, even a lawyer cannot say a woman was pregnant and that was killed, except he calls an expert witness in the form of a forensic pathologist who has actually done a forensic work on the dead woman to establish that she was pregnant. That's how fact and evidence-based legal practice is. But if lawyers have to work in the age of social media, you can see the tension that then exists between the hyper realities that are created and the obsession with virality that's created by social media, and the fidelity to evidence that lawyers are trained to uphold. So lawyers must walk a very fine line between the temptation to have to, exaggerate, and operating within the strict possibilities allowed by evidence, case law, and facts as allowed in court. The second point, of course, has to do with hallucination. AI is good, but it has a very strong capacity to hallucinate. Hallucination means, look, Dr. Tam George was the Dean of the Law Faculty, University of Lagos. It will tell you this, not only that it is not correct, but it will tell you confidently. And that is why lawyers have to be additionally careful. Sometimes
you may look at how not just the way it has been presented, but the confidence that goes with presentation of wrong information. There are AI platforms that say I was a dean of law faculty at the University of Lagos, but I was never a dean there. I've never been to the University of Lagos. I've never taught in that. Have I taught in other universities? Yes. In the course of my 30-year career, I've taught in universities mainly abroad, but never at the University of Lagos. I was never a dean there. But there are AI platforms that say I'm an Indian scholar who has taught at the University of Lagos. So you need to verify, double check, and make sure you exercise heavy dose of human oversight on the content that is generated by AI. And AI that does that is called generative AI, because it generates a prompt based on the input that you make. You know the story about garbage in, garbage out. If you are not careful, AI can generate wrong but confidently presented information. Woe betide a lawyer who just takes AI content and presents straight to it. It can cite cases that do not exist. It can cite precedents that do not exist, sections of the law that do not in fact exist. It can cite, laws that are totally fabricated but in a confident manner. That is called AI hallucination. And I think it's a major problem for AI users, especially in the legal profession, because in the US, in Florida, in New York, and elsewhere, there are already well-documented cases of, lawyers facing sanction by uncritical use of content generated using generative AI. All right, I'll be happy to take a few more questions if there's time.
Thank you, Chairman. There will be no need for now, because your lecture was vividly presented. Now, the next question, which has popped up so many times, is going to Sarah, the director. Sarah, are you there? The question says, why do we have to always launch every CPD program on new apps? Most people have no space to accommodate these apps in their gadgets. Would you respond?
Yes, thank you very much, Secretary. We have always been using Zoom, and then Zoho is a new platform which also accommodates people more. And I think all we just need to do is to go to Google Play Store and then download Zoho. It's not much of a challenge. It prompts you the way Zoom does also. So it's very seamless. And we keep new things keep coming, and we keep exploring the same. So I don't think it's a bit of a challenge. Thank you, sir. Then on the question that was asked earlier regarding the possibility of this link for the CPD being shared, I can confirm that has already happened. And to mention that on the call we have, I think some lawyer attendees are already dropping off. At 5:45 p.m. we had 268 attendees that are on this call, and on the CPD form we already have 4,498, meaning that 1,816 lawyers which are not on this call have signed in the CPD link. So we'll be using the attendees generated at this Zoho training section to issue the certificate. We will not be we are going to use the two data using this attendees list to issue the certificate, not the CPD link that has been shared to friends and colleagues to fill. So thank you very much.
Thank you. So the person that asked that question was not actually overthinking. So on that note, I say thank you from this end.
Thank you very much, Secretary. Now we'll be inviting one of the board members, Professor Eddie Tunwosu, to close the section for us. Thank you very much, ma'am.
Thank you very much, Sarah. I want to, on behalf of the board of ICLE, of NBA, thank the presenter for the great job he did this evening. We learn every day. I want to say that I have learned so much, notwithstanding the number of years being at the bar. Thank you so much. And I know that everyone here has learned something new. We want to thank the Institute of Communication and Corporate Studies for this collaboration with NBA ICLE. And we hope that this collaboration would continue as we work together to ensure that we develop professional competences. Thank you so much. I also want to congratulate the attendees. The number is quite impressive. Something ugly has been observed. We just pray and hope it doesn't continue. We should all become gentlemen, people of integrity. There's no point just ending a point without learning something new. And I thank God that we have a very proactive director who has come up with a way of ensuring that actually those who attended get the points recorded. So thank you, ladies and gentlemen. Thank you so much. Thank you, Dr. Tam George. Thank you for being a great blessing to NBA. And we pray that your work and your endeavors continue to prosper. Thank you so much. Have a blessed evening, everyone. And see you at our next ICLE.
Let me just plug in and say that our next course is actually coming on the 13th, Mastering Negotiation Strategic Skills for Lawyers. It's a wonderful course. I hope more and more people will subscribe.
Thank you so much. Thank you. So over to you, Director Sarah.
Thank you very much.
Thumbs up for you. Thumbs up, always.
Thank you so much. We are grateful to everyone and we appreciate your attendance. We do not take it for granted. We are in this journey together. And again, I keep saying this is our collective reality. My team and myself are here to serve you. Thank you very much. Have a good evening.